Thank you.
We are?
Yep.
Okay, good afternoon. This is the 22nd meeting of the Baltimore County Administrative Charging Committee. It's November 15, 2024. It's just after noon. We are in room 118 of the Baltimore County Historic Courthouse. First order of business is going to be doing a roll call, starting with me, Joan Harris, Dawn DeShawn-Fewer,
Tamisha Peterson.
Christopher Stewie.
Sharon Connect,
Sharon by WebEx. Okay.
Sharon Connect. Yeah.
And the next thing I want to do is welcome our newest member, and that is Tamisha Peterson. And she has already been fully trained, so she'll be with us today and mostly in an observational capacity. So we have to be on our very best behavior. We want to set good example. And the next thing we want to do is to approve our minutes of our last meeting from October 18. May I please have a motion to approve minutes?
Yes, be it so moved that the Baltimore County Administrative Charging Committee hereby adopts the October 18, 2024 meeting minutes as presented.
I have a second? Second. All in favor?
Aye.
Aye.
They are approved. And under new business, we are welcoming a guest today, and that is Captain DeCaro. He is in charge of the DARC, which is remind me again, Captain?
The Department Accident Review Committee.
All right.
Departmental crashes is how we refer.
And because we also review departmental crashes as a part of the work we do, every now and then, we do have questions that come up. It's not terribly complicated, the questions that we have. So we invited a representative to meet with us today and just to talk about what they do. So we appreciate your time here today. Could you start with just telling us the process of how it would come to you if a departmental crash has happened and it involves a civilian?
Sure. So first off, thank you for having me, and also thank all of you for doing this. I know it's an incredible amount of time and work you put into it. Not only am I an employee, but I'm a resident of the county. So I really very much appreciate that you have stepped up to do this. I'm going to be brief because the gentleman online, Sergeant Robinson, is our expert. He has taught driver training, and he also sits on the committee, the Accident Review Committee. So the way that this works is that when an officer is involved in a departmental crash, there is an investigation that takes place at the scene. And depending on the severity of that investigation, that may include an accident reconstructionist or an accident investigator whose certified full-time job is to investigate these accidents. Most of our accidents, thankfully, are relatively minor. So a supervisor will respond. We had a little bumper tap yesterday in Dundalk, unfortunately, very minor damage. This is just the reality of being, on the road and driving millions of miles, right? So the accident is then reviewed internally, right? So as I'm the ad hoc member of this committee as a commander, but I'm also the commander of Dundalk Station. That's my full-time job. So it would come through the chain of command in the precinct to me. I would take a look at it, and then I would forward it to our safety officer. Our safety officer is the conduit for our departmental accidents. And then the committee meets and they review the accidents for preventability factors. And
How often do you meet?
usually it's once a month, but sometimes it's not that often. It depends on the volume and then availability. So there's a supervisor of our department's crash team. They investigate our serious crashes, our safety officer, and then Sergeant Robinson. They are also on the committee. So I'm going to actually ask Sergeant Robinson to do most of the presentation. He's been doing this for a while. And what's great about his job is that he also does our continuing education drivers training. So when you're involved in some of the crashes, I'll let him tell you the criteria, you go to him for retraining. A lot of what we do here in this world is about risk management. It's about safety for the officers and the civilians, reducing the monetary damage that we're incurring, both to our equipment and also to the public. And retraining and remedial training is a big part of that. And he runs that operation down there as well. So I'll throw it over to Joe Robinson.
Good morning. Can you hear me okay?
Joe, you there?
Yeah, can you hear me?
Good morning. Yes, we can hear you just fine. Thank you for joining us today.
Well, thank you for having me. Yeah, so we convene once a month when we review these crashes. We've always used the term preventable or not preventable. When the state discipline matrix came out or became effective, I believe it was a year and a half ago, they used the phrase at fault or not at fault, which is a slight difference between the two. When we're looking at preventability, we look more at, is there anything that officer could have done based on their training or based on department policy that would have prevented that accident? 95% of the time, preventability and fault are the same thing. But there's a few occasions where we'll actually say that the crash was preventable, but not the officer's fault. And some of that might come into play where, let's say an officer's going lights and sirens through an intersection. By state law, the other vehicles have to stop. They have to yield the right of way to that emergency vehicle. The police officer's training is they need to stop, clear each lane, lane by lane, to make sure that the traffic is yielding to them. So if an officer is to get into one of those types of crashes, yes, they might not be at fault per Maryland law, but per their driver's training, per department policy, we might find that to be preventable. So I think that might be some of the differences between, we might say an officer could have prevented that crash, where if it goes to your committee, you might say, well, the officer might not have been at fault for that. Once we review all the crashes for that month, all of the crashes that are deemed to be not preventable, they will just be returned to the safety officer, and that officer supervisor in command will get a letter stating that that officer's crash was not preventable or not the officer's fault, and then no further action would be taken. Any crashes that we deem or determined to have been preventable, the safety officer will print off the driving record for that department member, attach it to the crash report, and I actually receive all of those, and I'll take them back to the training academy. One of the other driving instructors will actually sort through all of those. Not every preventable crash would result or require driver's training. Only crashes where the department member either has less than 5 years with the department would require it. So it's a lot of our newer officers. Or if they have had another preventable crash within the last 5 years. So if we have a senior officer, they've been on this department for 20 years, never had a crash before, or another preventable crash, their first preventable crash, they would not require driver's training. If they get into a second preventable crash within the next 5 years, that would trigger driver's training. That's only for property damage crashes. Any crash that's preventable that results in injury would automatically require driver's training. So once we get all those, we would send out the notices that department member is required to attend driver's training. And then me being at the training academy would also facilitate that driver's training for the department members.
I just
Sure.
One of the things that Sergeant Robinson is correct in, but the commands themselves can send members for training at any time at the discretion of the commander. So even if the accident review committee were to find one way, if the commander just happens to know or feel that an individual needs further training, it would not be considered discipline. That can be mandated. So sometimes you may see that in a mitigating circumstance. Or a mitigating factor that we could send over.
We have seen that, and we've sort of wondered why this time as opposed to not this time. And we didn't have an answer for that. Now we do. Thanks.
With that motion.
Sergeant Robinson, what goes into making a determination of whether an accident is considered major or minor?
That was something that was recently added when the state discipline matrix became effective. And that's actually, we added the captain's position, which Captain DeCara currently fills last July, I believe. Not this past July, the year before, July of 23. We asked for some guidance into how that would be determined, whether it would be, is the vehicle disabled, not disabled? Is it a monetary value of the damage? We didn't receive a whole lot of guidance on how to determine minor versus major. So they assigned a captain to the committee. They would review the photos from the crash. They would look at the physical damage to each vehicle, and then they would also consider the monetary value. And that's completely up to the captain that sits on the committee to decide minor damage versus major.
Guess we'll throw that question to you then.
It was the first question that I asked about where's the criteria. And oftentimes, I have a background in training. Oftentimes, the state will set these regulations and things like that, but they'll leave it up to the agencies to interpret. And those interpretations can be very wide ranging. So from my point of view, you have to take each accident in the totality. $5,000 worth of damage to one of our police interceptor explorers is not the same as $5,000 damage to one of our unmarked Ford Fusions, right? So you have to look at the totality, in my opinion, of the crash itself, the seriousness of the crash, also the monetary value, whether or not the car was totaled. Here again, a car with 200,000 miles is going to be totaled quicker than a car with 20,000. It may make more sense to fix it. So I have to look at that in its totality and just use maybe some common sense, which I know is a difficult thing to pin down, but it does require, I think, a level of subjectivity that I would prefer wasn't there, but it's guidance that we have from the state. So I think we have to use some common sense.
Yeah, it usually doesn't, I mean, it doesn't play a consideration during our deliberations. We just note that it's a part of the file. So we'll think and we'll scratch our heads, gosh, don't understand why this was deemed major when it was minor property damage, no injuries, but sometimes we'll see the major moniker on that accident because we are charged simply to find out whether, it's misconduct or not. And essentially we're finding fault or not. So it usually doesn't play into our, the work that we have to do. We just found curious.
It's uncharted waters for us too, because up until now, the previous 30 years that I've been here, accidents were accidents, right? And you would have to reach a threshold of misconduct or malfeasance, or have so many, we used to be 3 and 36 months, where then you would have a disciplinary aspect to it. So for us, we have conversations about this internally all the time. We're still navigating this as well, because it's not anything that we're used to. What we're trying to do in a lot of cases is change behavior. Sergeant Robinson talked about emergency response. That's one of the biggies, right? Because there's excessive speed. We are allowed to go through intersections, things of that nature, but it's also very risky. And, you would see sometimes where the public reacts, by, slamming on their brakes or doing something like that. So what we have to drill into the heads of our officers is that they need to slow down, pay even closer attention, right? And make sure they arrive at the original emergency, because if they create another emergency, then that's taking resources away. So it's about, in a lot of cases, altering behavior for our officers and, encouraging them to be as safe as possible. And this is why we say preventability. Even though the officer may not be at fault legally, they could, by following their training and what we expect of them, they could have prevented this from happening in the first place.
I have a question about what the training is with respect to when an officer uses his vehicle to block a suspect vehicle or to block something in prevention of an accident, because we've seen those kind of cases. And can you talk to us about that? Or can Sergeant Robinson talk to us about that?
Joe, you want to go first, or you want me to start?
I can kind of go over just what our manual says, our policy. There's different types of roadblocks and different techniques that some specialized units actually train to do, like our auto theft team. I think a tactical unit might have some special training, those types of things. But as far as like a forcible stopping roadblock, a lot of that is just used as a last resort. And that's really to just protect against an imminent threat of serious bodily harm, injury, death. That would be someone driving either erratically, whether they're intoxicated, under an influence of some type, going through a crowd, or it could be an intentional act, running through a barricade and heading towards a parade or an area has a lot of pedestrians walking around and intentionally doing something like that. So it does leave options for officers to take some of those measures, but a lot of that would just be as a last resort to prevent serious bodily harm or death to somebody. We don't touch a whole lot of that in our driver's training. A lot of the policy stuff that we would give, especially to the recruits, especially with pursuits, is stay behind the suspect vehicle, use alternative strategies, use the helicopter, use tire deflation devices, or even silent surveillance. That would be one of our more undercover, nondescript vehicles trying to follow the car as opposed to marked police cars with lights and sirens. So that's a lot of the training goes towards using alternative strategies during pursuit or minimizing risk to the public during a pursuit, and only using these types of roadblocks as a last resort.
So this is actually a topic of conversation that we're having internally, and it's been going on since forever. There are times when, as the sergeant said, we need to take some extraordinary measures. Some agencies teach active stopping and controlling of another vehicle with the patrol vehicle. We don't do that. Most of our roads aren't conducive to that. You know, if you've seen this, some of these are called like pit maneuvers, things like that, where the police vehicle is disabling the suspect vehicle. We don't teach that for a variety of reasons. But there are going to be times, particularly when we have people who are actively trying to get away from us, that the police cars are just kind of going to be there. And we have a situation where they drive towards us. The officers feel like the person is putting the public at risk. And if they happen to crash into our car, that may be better than crashing into a civilian vehicle. So we as commanders have to look at that and say, okay, is this acceptable judgment on the part of the officer, if it's an on-purpose type of thing? It's rare. You know, we don't often see this. What we do see is that the violators will sometimes hit us in an attempt to get away. But again, we don't encourage our officers to utilize their vehicles in that manner as a matter of routine for a variety of reasons. Again, most of our roadways, this is a pretty urban type environment. They're not conducive to that kind of stuff. So that's why we kind of, I think, shied away from that over the years. But there's going to be some times when, you know, that may be the better course of action. It's just a judgment call, and it's where we as commanders would have to review it and say, okay, you know, if you did that, you're going to have to justify, just like we would justify using a taser or, you know, something like along those lines. It becomes more of a critical incident at that point than just a normal crash.
It's not prohibitive as just a matter of course, it's just discretionary, but it has to be some
We
kind of.
built in an exception, but it is an exigency.
Okay.
Yeah, and we don't want the officers to create that exigency.
Right.
We would rather do what the sergeant was saying. You know, sometimes it takes time, sometimes we do alternative strategies, and sometimes people just get away. And, you know, there's often times when that's the safer course of action.
Anybody else have any other questions? No, what about Sharon? Did you have any questions?
No, he covered it pretty well, I
Sharon?
think. Yeah. I think the wording sort of is what we struggle with as fault and preventable. Because lots of times we don't find them that they're at fault, but that it is preventable, but they still aren't at fault. Does that make sense?
Yeah, because I think we've done that.
Yeah.
But we don't make a determination on preventable, not preventable. We pretty
Right.
much just do fault, not fault,
Yeah.
not fault. Right. Okay. Any other questions, anybody?
I actually have a strange question. Have you guys had the opportunity to review our opinions from accident cases?
I've looked at some of them, yeah, Major Corman.
And in the cases that Dark has said we should be charging them and we haven't, has that made sense? Like us saying they shouldn't be
So I
charged?
think Sergeant Robinson hit it on the head. A lot of it would come down to our collective historical knowledge for the department, our training, what our cultural norms are. This was out of policy. This was would have been preventable or at fault. We can understand how the committee here has gotten to the decision point. I don't think we've ever felt like they were worlds apart. Certainly, I don't think we've always seen the same either, which is, I think, by design. So, yeah, I think those things are apparent to us when we look at them. Sometimes the factors in totality, like Captain Carroll was saying, are enough for our group to say, just because you're an emergency vehicle doesn't mean you don't have to exercise due care and caution. And had you done that, we don't believe this event would have.
And I think a lot of the times that we would find someone not at fault, it's because somebody else was at fault. The
Right,
civilian
yeah.
was at fault. Or it was, we tend to look at it through I guess for lack of a better, more of a negligence standard, like if we were a jury, sitting as to whether someone is at fault, did the accident happen, but for this action, and so that's the standard because we haven't been trained departmentally as to preventable, not preventable. So it is kind of it's a weird sort of gray area because
This whole area of vehicle collisions.
it is.
I'm sure it's just as much of a difficulty for your group as it is for ours. Unfortunately, it was put on the matrix. The state put it there, right?
Right.
Should that ever change, would your committee still? I think there would still be collisions that would come here on occasion. It would be far less than you see now, right? Far less than we see. And so we're taking a process that has been in place, as the cap said, for decades, and morphing it to this relatively new system. So
Okay.
there's bound to be some differences.
All right. We appreciate though your being here today. Thank you so much.
Yeah, my pleasure.
Thank you.
We excused?
Absolutely. Thank you so much. for
Thank
coming
you.
here.
Thank you.
Thank you. It was nice to meet you.
And nice to meet you too.
If I didn't get a chance to meet, to
Oh, yeah.
introduce, this is Captain Brian Shanks. He's now with the Internal Affairs Division. Captain Eric Cross, at the last promotions, the chief, he got some new assignments, and Eric now heads the Woodlawn precinct. So,
Oh, okay.
so chief does that from time to time. He moves us around. Brian's with me now, so if you'll probably see writing his name on it.
Sure. All right. Thanks so much.
Thank you.
Great meeting.
Thank you so much.
Thank you.
See you next week.
Yeah.
Thank you.
Okay, so our next order of business is going to be a discussion of the policy recommendations, and I'm going to ask Henry to talk about that.
All right. Sorry. So you can remove me from the meeting if you want to.
Okay.
Just so that
Right. I made him an attendee, but then.
I'll just wait just so that he's free to stay, but it's not just getting out of these can be a little tricky. Spell. There. Sure. Okay. So as far as policy recommendations, I know last month Dawn presented several potential policy recommendations from the Administrative Charging Committee. And I've had the chance to review those internally and look through kind of what the policies currently say, what other jurisdictions state. And the big question is that if the recommendations are open-ended to the extent that it's, the ACC wants the department to look at the pepper spray policy and consider adding more detail to it. The challenge with keeping it open-ended is that it doesn't provide a lot of guidance to the department as far as where they want to, where they should go with it, right? Because their policies are reached through, again, their own process of internal review, looking at what other departments do, looking at what may be applicable to their department versus others. Some agencies have very, very, very detailed, for instance, pepper spray policies. Those policies, I think, are born out of specific instances that, because they seem very specifically tailored to things that have happened in the past. If we keep it open-ended, the challenge becomes, is it something that is actionable by the department, or is it something which makes it's so open-ended, they're like, well, we don't really know where to go with this, right? So for instance, on a policy regarding one of the things that Dawn noted was the creating some sort of standard for a response time for an investigator to a victim of a crime who's looking for more information. And the issue there becomes, it doesn't make sense to create a very specific policy on that where a violation could occur through good faith efforts where let's say an officer is, in court for a week testifying and they don't get back in a week. Well, it says you need to respond within X number of days and they don't do it. They can get charged. They would technically be run afoul of policy, but it may not make sense to charge them. So there's kind of pros and cons to both, but I think the question really is whether the committee wants to go down the road of making specific policy recommendations or not. So I think if they're general and open-ended, it's more likely to create confusion than to lead to better outcomes. And another thing worth noting is that whenever a policy is created, right, that can create new violations of said policy. And that's worth considering because it may make sense to say that with pepper spray, yeah, a more detailed policy would make sense, but do you want to recommend creating something which accidentally can lead to charges when it may not be necessarily relevant? So there's kind of the push here. The PAB is reviewing they will receive a copy of the first draft of the annual report on Monday. So no timing here is kind of tricky, but I ultimately just wanted to circle back and see where you all are on this. Cause I went through and reviewed it. I think with I'll say this for the response time question for, responding in a timely fashion. I think just again, putting in language, recommending language that says that an investigating officer will respond to the victim in a timely manner that allows for discretion by internal affairs and recommending charges and the committee in charging officers, right? So it can be something where if an officer doesn't respond in 2 months and IA is like, that's not appropriate, they can recommend charges there because that's not timely. But if an officer, to go back to that original hypothetical, is in court for a week and they don't have the time to get back to their desk, look over their file, respond to voicemails, that would probably not constitute a violation under that standard. With pepper spray, it's tougher because we can recommend they adopt standards that other jurisdictions have articulated, but I would say looking at some of those, they can be very, very tight restrictions that may create scenarios where an officer would be in violation, even if they weren't necessarily doing anything wrong, because it's a very subjective. Those are difficult ones, and there is already a requirement to render medical attention to officers. So there already is a requirement. Now, it's not specific to spray, but they are required to render medical attention. So I guess I'm interested in hearing if anyone has any further thoughts on this.
Well, and they're also required to let their supervisors know that they've used it.
It's a use of force. So yes,
So they're supposed to.
I think it's important for us to do our due diligence and recommend what we think is important. And I think the department is completely capable of writing the manual so it eliminates any possible, not eliminates, but decreases possible accidental violations of the policy. Like, they have some pretty smart people writing these manuals. So if we just say we're recommending a policy that would do X, Y, Z, but not be too specific, they can take that and run with it and create it with the intent that we had, but to cover what they need. That's my feeling. I think it's important for us to do. And I think the department's capable of writing these policies while thinking of all these other things, because they've done it with,
I guess
manual this
the
big.
question though, and I'm not pushing back for the sake of pushing back, because is with spray, I guess to Joan's point though, is it any different than a use of another force where they still have a duty under the use of force section in general to render medical attention if the person complains and requests it. I guess adding that into the pepper spray section may functionally, it's kind of redundant at that point. So I guess the question is, and my concern is, if we say, well, the department should update the policy on spray, they may come around and say, we already have these policies that are applicable to any use of force. If you tase somebody and they show cardiac issues, you have to provide medical attention. If you shoot a person, they need medical attention regardless. So why should spray kind of have its own carve out, I guess, is the question there. Because that may be, without a specific recommendation, that may be the response is we don't really know what to do with this. We don't want to come back and not be responsive to the ACC's recommendation or the PAB's recommendation through the ACC, or vice versa, ACC through the PAB, but we don't want to, like create additional stuff when it's kind of already there.
But
I
seems,
think-
it seems to me that what we end up doing is, because it's vague, right? So it simply means that we have to exercise our best judgment in reviewing the exercision of the officer's best judgment or their actions. So it just means it's broader and we have less guidance. So if we're okay with that, then we'll continue the way we have been reviewing these kind of cases. But mostly what we're looking for is just a bit of guidance, you
I
know?
think for the medical attention with the pepper spray, it's it's a use of force, but it's not the same as a gun.
Mhm.
It's not like if you shoot somebody, you're seeing them bleed, you're not calling 911, your paramedics are coming. Pepper spray is a different type of a use of force where you might not know
Oh, you would know.
the,
Yeah, because it's immediate pain in your.
but I mean, like,
eyes.
I think it's important to include, I guess.
I guess but I just.
It's not
getting
as-
at-
It's just
forward facing as a gunshot.
Shots on the pepper spray issue, because we're talking about whether the policy would be, yeah, go ahead, Sharon. Yeah, go ahead.
I agree with Henry. Maybe I missed something, but I didn't find that the use of pepper spray was abused. And certainly when you pepper spray somebody, they've been pepper sprayed. I mean, it's not like, oh, wonder why his eyes are watering and he can't breathe real well. I mean, it's not like it's hidden. I think we're trying to pigeonhole too much. You've got to let the officers have some discretion and not have to have them think about another rule and how it should be used. I mean, this is real time stuff happening. I just think that, I don't think it's necessary.
Okay. Anybody else?
What was the policy recommendation? Pepper spray again?
The recommendation was to have a more detailed pepper spray policy after the person sprayed what the officer is supposed to do. And a lot of jurors, looking at
In regards to medical attention.
in regards to medical attention.
Correct.
So other departments have guidelines, but they vary dramatically. So some departments, Baltimore City is like a 30-part checklist of what officers have to do. And that's the one that I think is probably something where there was a specific incident and there was probably outcry that necessitated, this. I think, and most departments have some variation on what Baltimore County has. Baltimore County is basically render medical attention, observe, basically tell them the only thing that will resolve it is time and air, and then basically render or request medical attention if the person has an unexpected reaction. Because obviously the purpose of spray is to essentially subdue the individual. That's going to cause pain. So other jurisdictions may be like, remember that, water is important too. And remember that, it's important to reassure the person who's been sprayed that they've been sprayed and that, they'll be okay. So it's a lot of additional and part of the reason that not concerned me, but that kind of made me pause is that in reviewing the other policies, it seems very easy to say, well, the officer didn't reassure the member of the person while the person was, thrashing and violent and angry and yelling. And I think it kind of creates potential issues where it's walking into it's essentially creating violations in an area where the officer was exercising their judgment. And I think that it's very different than the policy recommendation to respond in a timely fashion, where I think that language by saying timely is open-ended enough where it gives discretion, but it allows for the ACC to charge if it's looking from a practical standpoint, IA can say this person responded within 48 hours. We don't recommend charging. That kind of gives a clear guidance to the ACC. And it's not something where the officers are really walking into violations when exercising good faith. I think the problem is I would not advise, I'll put it this way, putting a general statement of saying the spray policy should be more detailed without going into any further specific details. Because the PAB policy recommendation.
Yeah, I understand. So.
Right, I know I'm going on and on a lot.
But should we take a vote on it then, or how do we because then this is something that Donnie would take back to the PAB that would make it into some report, right?
The annual report. with
Right,
the
so
issues.
the question is then and we've already voted, I think, on the policy of getting
We-
back to people in a timely manner, that is.
We didn't
We have
vote
recommended-
to adopt, no, the recommendation was that I go back and kind
Okay.
of do this and come
All
back
right.
with some.
So of these
specifics.
two pieces then, with respect to recommending a policy of having the investigating officers respond to victims or witnesses in a timely manner, we believe that still should be something that we forward to them.
Mhm.
Let's take a vote on it. Do we all agree? All of those in favor?
Aye.
Aye. And,
No, if I can explain.
Sure.
I just find timely manner to be a little bit too vague.
I think that's the idea, so that there's a certain amount of reasonableness, because we don't want it to say must within 30 days if the
I think we need to
officer is-
remember too, our recommendation goes to the
finish.
department for their consideration. They can
Right.
take it and create a policy that says something within that, but doesn't say
They're-
timely manner.
I would imagine they're going to want to work within what the PAB recommends, because the opposite is to not recommend what the PAB not do what the PAB recommends.
But I think they can follow the recommendation and tweak it, because like, we aren't policy writers. We don't write field manuals, like, so.
Although that's kind of what the PAB is tasked with though, right? Like to make those specific recommendations.
I don't think we're equipped enough
Okay.
to write policy. That's my opinion.
Yeah.
Like, I think it should go to the people that write the midfield manual for them to.
Okay.
Do
And
as
I
they
think with the
fit. That's
time,
my
the
opinion.
timely, I think that gives
Right,
enough.
so- But this is something that we have voted on, that we
Sure.
would like Donnie to take to the PAB and say as a policy recommendation, this is something we would like to
Could we,
have them address.
I mean, we
right?
could even say like, we're recommending the department create a policy to ensure that they're responded to in a timely manner. So that policy could be
Yeah. I
something
mean,
more specific for them if that's what they see fit.
Yeah.
But we're still getting our
Yeah,
goal
we're-
I mean,
across.
what, yeah,
What
I
we can
mean,
do as a committee is make a recommendation.
Correct.
The policy
And-
arm is the PAB.
and that one,
So-
to be clear, the other agencies do have some equivalent language that says, an officers respond to, and it's specifically for the victim.
Mhm.
So that way it can't be like a witness who's like, hey, I was wondering,
Yeah.
and then they have to,
Okay.
well, they don't have to respond to a witness and provide details. But a victim of, a gunshot wound, for instance, which may, they haven't heard back in 2 weeks, they might want to call back and get a response.
Yeah, and I think if we're saying, we're recommending they create a policy, they can include all of the caveats in that, unless they're in court, unless they're away, unless they're in a coma, things like that. Like if
Okay.
we're recommending a policy be created with the goal to X, Y, Z.
I'm only pushing back on that because I really just think that creates, I think unless it's a specific policy, it's just going to run into the issue of them coming back and saying, well, we don't really know what you want. And they're going to want to be responsive to what the PAB wants. 'Cause then it looks like they're disregarding the Police Accountability Board's report. I mean, I can tell you specifically actually what language I drafted as a note just to see if this flies. The language was Baltimore County Police Department Manual 15.2 should be amended to require investigating officers to, quote, provide a timely response when a victim inquires as to the status of the investigation. Such a policy would require investigating officers to provide responses to victims of criminal activity without prescribing a set time to respond, which could potentially impede their ability to conduct other police activity.
Yeah, I like it. Anybody have anything to add to that? Because the idea is to make it reasonable, but it's about, remember before, there was no policy to get back to anyone. We had cases that were like that. And that's why we pointed it out as something that maybe we could take a look at later.
Personally, I think it also gives IA the ability to say, look,
It's very discretionary.
this is someone who waited, 2 months to respond. We recommend charges. And it gives the ACC something to actually charge on, whereas currently there wouldn't be something they could really
Can you say
charge.
that language one more time?
Sure. The specific would be provide a timely response when a victim inquires as to the status of the investigation. And that it would be added to a section that already deals with how to handle an investigation. When you have, so for instance, there are requirements that they do contact, but there's no requirement to do a timely response or any kind of, it says kind of stay in touch, but it isn't. The way I read it is the officer's supposed to let the witness know when stuff's going on, but there's nothing there's no requirement that if the victim reaches out, the officer has to get back to them.
What do you do with people that call repeatedly?
Well, I think that's different than because they just have to respond timely about the status of an investigation. So if there's nothing going on in investigation, I think that's the out, is that there was nothing happening, so I didn't get back to that person. But that falls also under potentially an unprofessional conduct. We've seen those kind of things come under that banner before. They've also called it discourteous because they thought it was discourteous not to respond to people who call all the time, but,
But if they're required to respond every single time somebody calls and someone calls every day.
right. Well, I'm
or
just,
once a day.
I would like to know if we should just go ahead and take a vote on the language Henry has proposed. We've basically taken a vote that we wanted to do something to make a recommendation. So I can put that on the floor to take a vote, or we can table this for another time. We don't have to do it during this reporting period. We can put it on another agenda to discuss it further. We don't have to make the decision today.
And it is also something where even if it's not included in the annual report, there is still the ability to make recommendations to the department. I mean, there's a lot of times where I will, because you asked a question, I'll follow up with Major Gorman. And I think the PAB is not limited to, in their annual report, to make recommendations at that time. The annual report really is, I'll tell you that the key part for the annual report is that if there's something that requires a statewide legislative change, you want it on the books in December. And there are a few that are in this one. The year and a day tolling deadline for criminal cases is the big one. If it is something where this committee would rather discuss and potentially have a conversation with IA about it, if that's the way you all want to go, that's fine. I mean, I'm basically saying you guys can do whatever you want to do with this, and I will make it work logistically.
Right. The only reason why we're talking about these issues, these policy changes, because we talked about it before, but we're doing it now because of the timeliness involved in putting together an annual report. So it was a question of whether our recommendations make it onto an annual report. We don't have to. We can certainly table this for another time when we have some more information that we want to gather.
The intent of the annual report is for state changes. I'm okay to table it
Yeah.
and figure out a different way to accomplish what we
Yeah,
want
'cause
done.
we've already determined that this is something that is, we
Yeah.
want to deal with it. We've talked about this before.
Yeah.
We've had cases that involved it, and we thought there should be some policy involved with it. So,
Sharon.
yeah, Sharon's got her hand up.
I got my hand up. I wondered if we
Okay.
if we could put something in there to eliminate the traffic cases, to be honest with you. I just think it's-
That's already in there.
Yeah.
It's in there.
That's in there
Right,
because
it's
that's
in
again an example of what would require a statewide change.
Yeah, well,
We're
as
covered on
long
that,
as,
but it doesn't mean we,
as long as somebody's aware
So,
that
let me
it's
do
kind of
this.
a waste of time.
let's do this. I would like to make a motion to table the discussion of additional policy recommendations.
Second.
All in favor?
Okay.
Aye.
Okay.
So we'll be retracting what we had in the annual report draft.
Yeah, well, there,
Okay.
and right now, I have
Yeah,
not I
fine.
did not add it because I wanted to review with everybody
Yeah.
first. I can tell you this, for instance, with spray, I drafted them as if they would be in there, and the spray one's like 3 pages long because it's looking at what all the other jurisdictions do, and it gets really, it may be worth something where we can flag for the team that works in the department, because my only concern is if PAB is recommending something, it's going to become a source of conversation. And if it isn't resolved in a way, if it creates more, that kind of puts the target on the department, so to speak, to come up with something. And if they don't, then it's, oh, well, the department isn't responsive. Or if it's too vague, then it becomes meeting, they'll probably want to meet with the PAB. They can discuss it with the PAB and the ACC, and they probably should, but there's other ways to get there without kind of being like, you got to fix this.
Okay.
Maybe that's the answer. We could request to meet with the policy team periodically,
Mhm.
especially because if we're sending something to the PAB and then the policy team's responding to that, the PAB doesn't have as much information as we have.
Yeah, I think it's fine. I mean,
Yeah.
I
think
like I
that's-
said, I'm happy to invite. I know the chief's come before. He's happy to. I know the policy team is happy to come in. And there's Chief of Policy, Meg Ferguson, who spoke at the PAB meetings. I think she'd be probably happy to come into the ACC.
I think that's a good route.
Yeah.
If we,
And I also
Okay.
think that because, and this is just to refresh all of us, and also because this will be the first time Tamisha's heard about this, but As-
She's getting
as-
thrown in on.
no, but as we have reviewed cases, we sometimes, we find out there is no particular policy on a particular set of circumstances. And then we will ask Donnie, because she is the PAB representative on this committee, we'll ask her to make a note of things that we may want to discuss with PAB, or we may want to discuss things with the police department about those issues. And, you know, with a mind to, maybe this is an opportunity to not only just discuss, make some changes, find out more information. So we try to do that. You'll see when we get into discussions about things and we recognize that there's no fix for it. So that's what we're going to pay attention to. And so we've tabled those things for the time being. And
I'll just tell you guys what's in the report as far as the policies
Okay,
themselves,
go ahead.
based on conversations. One of them is an internal that we again can discuss the PAB meeting, which is a different group than this. The Don's on both.
Monday,
Monday.
anybody wants to come?
That's all open to the public. It is to toll the year and a day deadline for cases where the officer is also under criminal investigation, because that creates headaches. I don't know if they flag that in training as something to be aware of, but that becomes, that year and a day drop dead date. So second one is it's a Attorney General's recommendation, which is not in the law, but I think probably should be, which is that if a member of the public withdraws their complaint, the case must still be investigated, because that avoids the perception of individuals being, withdrawing it under pressure or scrutiny. And if the officer committed wrongdoing, that still needs to be investigated. The third one is to address the departmental accident cases, because there's some, I think, concerns that was even intended to be in the legislation to begin with. To remove those. The fourth one is the one that I flagged and that our internal team flagged. Rebecca Young, who's the deputy AO for public safety, and I have both run into this issue, which is requiring the training commission to adopt an annual schedule and keep to it and flag it, because had they not had the training when they had it, Tamisha wouldn't be able to sit here today as part of the meeting. Likewise, had Tiffany Justice stepped down in June, I don't think there was any training between June and November. So that creates significant problems also for trial boards. Trial board training is extremely erratic. And I think having a regular schedule ensures that no jurisdictions sitting around waiting, unable to do things because they haven't gotten people trained. And if two members of this committee had dropped off, that would have created even, or let's say that we have a great member who's qualified, they can't attend the next training. They got to wait until the next one. And that's not, I have no idea when the next one is. They don't have a next one scheduled yet.
yeah, that's great. All right, these are good things. Anything else before we motion into closed session?
I guess two things to add, Henry, for that training thing. Any possibility of having virtual trainings or an interim training for someone just in case there's a long time period?
So that kind of got jumped on already by the governor's office kind of flagged that. So the only reason why I didn't include that is because I think that is like a balancing act of I think you all benefited from being in person to do work through the scenarios.
Yeah.
But at the same time, I agree that some of it could be made virtual. But the governor's office hosted a forum, and their recommendations from the internal affairs people and from people like myself was basically find a way to make it logistically easier than having people drive to Sykesville for a week. Because not all members live in Owings Mills, which is a short drive.
Lucky.
Okay.
Some live in Carroll County, some live in the Eastern Shore. So that, I think, just trying to get a regular schedule first, and then from there being can we do 2 days remote, 3 days in person, or 2 days in person, 1 day in person, the rest remote, whatever the case may be.
All right.
All right.
Anything else? All right, can I get a motion to go into closed session, please?
Yes, so move that the Fulton County Administrative Charge Committee hereby meets in closed session to review investigatory files in compliance with section 3-3-2806 of the Fulton County Code and FOMAR 12.04.
Okay.
I'm gonna resume now. Good.
We're back in?
Yep, we're back in open
Alright.
session.
And at 4:18 PM, we are back into open session, and I think we just have one more update from Henry.
Yep. Sorry guys for the delay in getting to this, but I did want to provide a trial board update. So I think we've gone over the overview before on that, but there was one on October 22nd and 23rd. Officer was accused, that one was going to be on October 2nd to 23rd. It has been postponed due to illness of one of the counsel in the case. There was a trial board called for November 6th. The officer was charged by the ATC with failure to take necessary police action by failing to issue a traffic citation for leaving the scene of an accident, failure to recover document evidence, violating investigative procedures, and failing to write a required report. The officer was found guilty of failing to recover / document evidence and violating investigative procedures, and not guilty of the other charges per agreement. Trial boards called for November 18th involving an officer charged by the ACC for a departmental car crash. On November 25th, 26th, there is a trial board involving a officer charged by the ACC for a departmental car crash. There's a trial board called for December 2nd for body worn camera violation. There's a trial board called for December 17th for unnecessary use of force, rude and discourteous conduct, and conduct unbecoming of a Baltimore County police officer. And there is a trial board called for January 7th involving an officer charged by the ACC for failure to take necessary action on a call of a violent mental disorder. Those are the pending ones, and I will continue to let folks know how they play out as they go along. So.
All right, thank you. Any other from anybody else? No. All right, at this time, may I please have a motion to adjourn this meeting?
Yes, be it so moved that the Baltimore County Administrative Charging Committee hereby adjourns until December 13th, 2024 at 12 p.m. At which time it shall meet in room 118 of the Baltimore County Historic Courthouse and by WebEx.
Second.
All in favor?
Aye.
And we are